The Constitutional Convention met with the intention of revising the Articles of Confederation. However, as it progressed, it was agreed to begin work on a new framework of government, which would become the Constitution. The main problem with the Articles of Confederation was the power imbalance. Too much power was left in the hands of the states. To address this, the Founding Fathers adopted federalism, with power divided between the states and the new central government. Today, federalism can be seen at work during the pandemic, where the governors adopt measures in compliance with the guidelines of the federal CDC. However, the partisan nature of 2020 politics has put the existing situation in peril. With 13 separate states, some with over 100 years of history, getting agreement would be difficult. Compromise was the order of the day. The Great Compromise created a bicameral legislature, an upper house of equal representation, the Senate, and a lower house with representation based on population. The 3/5 compromise addressed the issue of slaves and representation and taxation. The commercial compromise gave the federal government control of interstate commerce, but left intrastate commerce in the hands of the states. The federal government could also impose tariffs on imports. The new government had a simple majority to get the legislation passed, and the ratification of only 9 of 13 states was needed for the Constitution to become law. With the document finally completed in September 1787, the arguments over ratification began. Federalists supported ratification. Theirs was a strong case. Mostly lawyers and thinkers, they saw the need for financial stability, an approach that appealed to the money classes in society. With this financial support, they set out to win the hearts of the people. They had a firm plan and a framework of government. The anti-federalists, more revolutionary idealists, could merely argue what could happen if the Constitution were adopted. Their fear of a tyrannical government, a la George III, seemed unwarranted, and they saw the future only in short-term gains. The odds were in favour of the Federalists, and their financing and organising convinced George Washington to support ratification. With his reputation and leadership, his vote was crucial. The Federalist Papers, 85 anonymous installments in newspapers, went in a line-by-line argument of why the Constitution should be ratified. Written by John Jay, James Madison, and Alexander Hamilton, they focused on human nature, national power, democracy, limited government, society, and freedom. For example, in Federalist Number 10, Madison argued that a larger public would control the different factions in America. 4 Federalist Papers have been assigned to this course, so it is important to read them. Finally, the anti-federalists agreed to the adoption of the Constitution if a Bill of Rights were to be included. The Bill of Rights was adopted in 1791 and protects the rights of citizens. Broken into a preamble and 7 articles, the original Constitution is only 4,500 words long. The average state constitution is 26,000 words. Alabama's is 172,000 words long. Its brevity makes it clear, direct, and concise. And it is this fact that makes it the oldest living constitution still in existence today. The preamble sets out its goals: a more perfect union, better than the Articles of Confederation. Ensure domestic tranquility so people can live peacefully, and promote the general welfare. Today we have social security, environmental laws, and numerous others that let people pursue a life of liberty and happiness. We see here the framework of government outlined in each article. The Constitution looked to redress the imbalance of power in the government of the Articles. Power, its source being the definition of type of government, is divided between states and federal governments. It is specifically spelled out who has what power. Powers given to the federal government are expressed or enumerated or delegated. Section 8 of Article 1, the Elastic Clause, expands on this power, allowing the government to pass laws that are necessary and proper. Some powers both state and federal government have. These are called concurrent powers. And finally, all the powers not given to the federal government and not denied to the states are reserved for the states, like education, marriage, driver's licenses. If it's not given to the federal government, and the Constitution doesn't say it can't have it, like New York making a treaty with another country, then it's a state or reserved power. The 10th Amendment is where reserved power clause is located in the Constitution. The majority of the articles then deal with this power. Articles 1, 2, and 3 list powers given and denied. Article 4 addresses the states and recognizes a limited sovereignty and spells out their relationship with each other. Laws of one state are recognized in another state. A New York driver's license allows you to drive in every other state, and vice versa. Finally, Article 6 decides the issue of which law is higher, state or federal. This is called the Supremacy Clause. Federal law is the supreme law of the land. The password for today is supremacy. I repeat, the password for today is supremacy. Within the Articles 1, 2, and 3 is the division of power that Montesquieu wrote about in the spirit of the laws. Giving each branch power allowed them to work together without one becoming too dominant. The interrelation of government branches allows for balance and reasonable debate, and the opportunity to look at issues from a legislative, executive, and judicial point of view. Within the system, checks exist where branches must approve of the other's actions. This was established to allow for greater consensus. So each branch has its basic function: make, enforce, and interpret the law, but there is a break on their power. It is important that the student refamiliarize themselves with the system of checks and balances. Implied power expands greatly the power of the federal government. A loose interpretation allows laws to be passed today that may be deemed necessary and proper. Indeed, Jefferson, a staunch anti-federalist, used implied power to make the Louisiana Purchase in 1803. Many critics today, however, hold that the implied power infringes upon those rights enshrined in the Bill of Rights. Laws concerning the internet, regulation of so-called hate speech, FISA court applications, all have been passed, but sometimes overstep the boundaries of personal freedoms. Following the Marbury versus Madison ruling, the power of the judicial branch became much greater. Early on, it served to strengthen the national government using a loose interpretation of the Constitution. The McCulloch ruling found the Second Bank of the United States to be constitutional and clarified that states could not tax the federal government due to the Supremacy Clause. Interpreting the law and striking down laws as unconstitutional is seen as judicial activism Critics feel that the Supreme Court is performing as a type of legislative branch, deciding what law should be allowed and not be allowed. Liberal judges will rule against conservative law. Today, conservative justice view the Constitution through an originalist lens, interpreting it as seen from its original meaning. Please answer the following questions and put your answers in the relevant Google document, etc. Thank you. I will allow X amount of seconds per question. Thank you. This concludes our lecture for today. Thank you.